To WSB Atlanta. Kendrick Johnson, appeals court says family's lawsuit should be looked at again. Story by WSBDB.com news staff. Kenneth and Jacqueline Johnson stand next to a banner on their SUV showing their late son, Kendrick Johnson, who died in 2013. The Johnsons were not happy with a report released by the Lowndes County Sheriff's Office, copyright Respinum/Associated Press, file. A Georgia appeals court ruled that a lawsuit filed by Kendrick Johnson's family should be reviewed again after a judge dismissed it. In January 2013, Johnson was found dead in a rolled-up wrestling mat at Lowndes County High School. Investigators ruled his death an accident. Johnson's family has maintained the belief that he was killed. Live action news. Federal court revives family's fight for teen found dead in Georgia high school gym mat. Law enforcement ruled twice that Kendrick Johnson's death was a tragic accident, but the family claims their civil rights were violated. Author Lars Lonroth. Published 6:17 p.m. Eastern Standard Time, February 24th, 2025. Updated 9:52 p.m. Eastern Standard Time, February 24th, 2025. Atlanta, a death at a Georgia high school has landed before a federal appeals court in Atlanta, but the judges were split on legal arguments by the victim's family. In 2013, sophomore Kendrick Johnson was found dead at Lowndes County High School in Valdosta. They found him suffocated inside a gym mat. Law enforcement ruled his death a tragic accident, closing the case. The case was later reopened in 2021 due to public outcry, prompting additional scrutiny from local authorities. But the authorities said the situation was the same. They ruled Kendrick Johnson's death an accident. His family disagreed. They argued there was more to the story, citing an independent autopsy and problems with the school's surveillance footage. A wide-ranging lawsuit, filed by Kendrick's parents Jacqueline and Kenneth Johnson, argues that their civil rights were violated and a federal judge improperly threw their case out. The Johnsons also argue that the judge should have recused herself. But at the federal appeals court in Atlanta, a 3-judge panel ruled February 21st that the judge overseeing their case, U.S. District Court Judge Lee Martin May, was right to not recuse herself. However, they ordered the decision to toss the case out be reviewed. While the Johnsons argued that May was biased against them, the judges wrote that their evidence was not extrajudicial, forces out of the courtroom, and instead was based on frustrations with May's handling of the case. Because they didn't prove that May's alleged bias stemmed from outside the courtroom, May was in the right in not recusing herself, the judges ruled. Another problem the trial court found was that Johnson's lawsuit was filed against entities that can't be sued, including the G.B.R, the Lowndes County Sheriff's Office, the Valdosta Lowndes Crime Lab, and the Lowndes County Board of Education. That's why Judge May threw the case out. However, under Georgia law, the Sheriff's Office can't be sued because they are part of the county. Because of that, the county must be sued. The Crime Lab, a part of the police department, is an arm of the city, so the city must be sued. Lastly, the County Board of Education itself can't be sued. Instead, the school district is the entity that can be sued. But May's decision to toss the case failed to recognize, the appeal panel said, that the lawsuit's incorrect naming of defendants could be fixed. Because of that, the decision to toss the case should be reconsidered. While there were other points that still could be grounds for dismissal, the judges sent the case back down to the U.S. Northern District of Georgia to consider those arguments and whether there was still enough evidence to toss the case out. Both parties will have the opportunity to outline their case before a judge in the Northern District of Georgia, rehearing the case and allowing the family's legal battle another opportunity to be heard.